007 of part.
As a heading for order serial number 16, Sanjay Kumar Chauhan versus the state of Bihar for the Christmas Church.
Your Lordship, for few cases, Your Lordship may accommodate for senior counsel. These are only for few cases.
Is in orders list. What is the IAS and all?
IA has been allowed.
Then all the 6 IAS are pending.
No, IA is
Showing it is pending.
3 IAs, I believe, my lord, have been allowed, by which impediment has been permitted.
Huh?
3 IAs, my lord, have been allowed, by which impediment has been permitted, my lord, of persons who were
It is intervening.
interventions, my lord, for impleading them as party respondents, as their rights might just be adversely affected in an event the writ application is allowed. Now, my lord has also taken note of the number of interlocutory applications for intervention had been filed on earlier occasions. My lord had passed the last order, which may kindly be seen. My lord had indicated that
Already, impleading respondents have filed their counter statement.
my lord, it is by way of that interlocutory application, we have stated the relevant grounds. So separate counter affidavit,
Need not.
it is not really needed.
All right.
for a few cases, Your Lordship may accommodate.
Not few cases after January.
Then Your Lordship, I may be allowed to.
Address.
Lordship, by this writ application, virus of the rules as provided as
What is the status of the petitioners?
petitioner's diploma holder of civil engineering. If Lordship may allow to give some brief facts. The advertisement was issued, advertisement 1/2019, dated 8/3/2019.
What is the date of advertisement?
8/3/2019.
8/3/2019. Advertisement for what post?
For junior engineer.
Junior engineer. How many posts?
6,379 posts.
637?
9 posts.
6,370.
1,379.
Yes.
Lordship,
Where are the rules of recruitment governing the post of a junior engineer?
that is annexure 1.
Annexure 1.
So for fill-up date, Your Lordship may, I am giving some dates, Your Lordship. The date for filling up the form was 11/3/2015 to 15/4/2019.
What is the 11? That is that date.
Date for filling up the application.
Sir, before that we want to see what is the method of recruitment.
Lordship.
Where is this rules of recruitment of a junior engineer post?
Annexure here, 1, Your Lordship, may kindly see. It's a qualification prescribed. At page 21, annexure 1.
No, the title of the rules is Bihar Water Resources Department Subordinate Engineering Civil Cadre Recruitment Amendment Rules 2017. Correct?
Lordship.
Where is the junior engineer post mentioned and what is the qualification?
It is there, my lord, on the following page, my lord would find. It is there, my lord, the following page number 28, my lord would find.
Where do we get?
Following page, it is there, procedure of selection. Rule 2 that has been amended by way of the present rules, my lord. Selection to the basic category of junior engineer civil of this cadre shall be made by the
On
committee.
page 28.
29, my lord. 28, the rules start, my lord. 29, procedure of selection has been indicated, my lord. Selection to the post of basic category of junior engineer civil of this cadre shall be made by the commission on the basis of percentage of marks obtained in diploma or equivalent qualification.
What is next page?
Page 29, top, my lord would find. By way of this amendment rules, my lord, this rule was inserted in place of the earlier rules. Procedure for selection.
Yes, what is the qualification prescribed?
Qualification, my lord, is diploma it is written there only shall be made by the commission on the basis of percentage of marks obtained in diploma or equivalent qualification. Such candidates having experience of working on the post of junior engineer civil on contract basis under the government of Bihar or in any undertaking corporation. Annexure 1 million. On contract basis under the government of Bihar or any undertaking corporation, body, authority, autonomous body under the government of Bihar who fulfill the qualifications of the recruitment in this cadre shall be given preference by additional marks according to sub-rule 2B of this rule. Then merit list of candidates shall be prepared on the following grounds. A, my lord, is on the basis of percentage of marks obtained in diploma or equivalent qualification, maximum weightage for working experience, 5 marks for each year of contractual appointment, my lord, to a maximum of 25 marks for 5 years. My lord, the learned senior counsel representing the petitioners is here, my lord. So,
my lords, I have a limited grievance. I have challenged the validity of Rule 913A, page 28. Page 28. Diploma holder in civil engineering from institutes recognized by AICTE, which has obtained diploma from AICTE/university. All the petitioners, my lord, were applicants. Their application was received at the time of counseling. The commission, my lord, took a stand that according to this rule, unless the qualification is acquired from a university which is recognized by AICTE.
No, there is no university, institute recognized.
Recognized, yes. They say institute, they take institute as if it is any.
By AICT.
Now, this issue, my lord, the interpretation put forth by the commission is contrary to law declared by Honorable Supreme Court. Honorable Supreme Court has held in Bharti Darshan case, followed by successive judgments, even latest judgment of 2022.
According to you, the a diploma certificate holder who is not, whose institute is not recognized by AICT is not.
No, my lord. Diploma holder from a university. That university is not required to have.
The option AICT has obtained diploma from AICT/university.
My lord,
or a diploma in civil engineering by non-distance mode and other things.
We are not concerned with B. We are concerned with only
We are concerned with the only university.
University.
Which university? Which university?
Petitioners have acquired diploma qualification from different universities. They are, some of them are private universities.
Correct. There is no specific university.
Yes, my lords. Now what they say is that since these universities do not have prior approval from AICTE and therefore the qualification would not be treated as valid.
In other words, the institute is not approved by AICTE.
That's right. That is what is being interpreted by the commission. This issue is no more res integra, my lord. Way back in 2000, the first judgment came, my lord. I have given the reference of book.
So where is the decision of the respondent that
that they have not conveyed any decision, they have just shut us out from the counseling.
Where is your contention that they have rejected your claim?
Yes, my lord. My specific.
Only because this your institute is not recognized by AICTE.
My lord. That is in paragraph 9 and 10, page 18.
Read para.
Yes. That in pursuance of a aforesaid advertisement, the petitioners being eligible submitted their application online with cutoff date. It is further stated that time of online submission of application, name of universities from which petitioner acquired said qualification were shown amongst list of universities on the portal of commission. Accordingly, applications submitted by petitioners were accepted by commission and subsequently they have been allowed to participate in the counseling. However, in the process of submission of objection as invited by commission, Petitioners acknowledge that on portal of commission in marks column, 0 was shown, and in the remarks column, it was mentioned that qualification of petitioners are not as per terms of the advertisement, such as institutions are not approved by AICT. The petitioners are suggested to bring on record a status report of one of the petitioners as shown in the website of the commission for convenience of this honorable court. That is further stated that commission has arbitrarily denying the eligibility of petitioner, whereas students of same university institution were selected by state and central government from time to time, and they are still working in
Where is challenge to Annexure A3?
Annexure A3.
Where have we challenged?
Annexure. My lord, this is not a communication, in fact.
No, it is portal. What is that? It is
My lord, with great respect, my lord, if I am challenging the very rule, then I need not go to my lord's.
all right. You need not challenge.
Yes, I am challenging the very rule.
All right. We'll accept that.
Yes. Now, my lord.
Record also.
Yes.
That we need not challenge.
My lords, I will be relying on 3 judgments of Honorable Apex Court. Kindly come to my lord first judgment. That is 2001 8 SCC, page 676.
Give this side.
I have given my lord.
One 8 FCC.
Omgar.
Para.
Kindly, my lord. Paragraph 8 onwards, my lords, may kindly see. We have bestowed our thoughtful consideration to submission made on either. Para 8, page 683. Here was a question, exactly same question. We have bestowed our thoughtful consideration to submission made on either side. When legislative intent finds a specific mention and expression in the provision of the Act itself, the same cannot be whittled down or curtailed and rendered nugatory by giving undue importance to so-called objects underlying the Act or the purpose of creation of a body to supervise implementation of provision of the Act, particularly when AICT Act does not contain any evidence of an intention to belittle and destroy the authority or autonomy of other statutory bodies having their own assigned roles to perform, merely activated by some assumed objects or desirability. The courts cannot adorn the mantle of the legislature. It is hard to ignore the legislative intent to give definite meaning to words employed in the Act and adopt an interpretation which would lend to the violence to express language, as well as on plain meaning and in patent aim and object underlying the various other provisions of the Act. Even in endeavoring to maintain the object and spirit of law to achieve the goal fixed by a legislature, the courts must go by guidance of the words used and not on certain preconceived notion of ideological structure and a scheme underlying in law. In a statement of objects and reasons for AICT Act, it is specifically stated that AICT was originally set up by a government resolution as a national expert body to advise central and state government for ensuring coordinated development of technical education in accordance with the approved standard was playing an effective role. But however, in recent years, a large number of private engineering colleges and polytechnics have come up in complete disregard of guidelines laid down by ICT, taking into account serious deficiencies of even rudimentary infrastructure necessary for imparting proper education and training and need to maintain educational standards, curtail growing erosion of standards. Statutory authority was meant to be conferred upon AICT to play a role of more effectively by enacting AICT Act. Now, after having considered all this, my lord, then the Honorable Supreme Court in paragraph 15 onwards To put in nutshell, paragraph 15, page 689. To put in a nutshell, a reading of section 10 of AICT Act will make clear that whenever the Act omits to cover a university, the same has been specifically provided in the provisions of Act. For example, while under clause K of section 10, only technical institutions are referred in clause A of section 10 provides for guidelines for admission of students to technical institutions and universities imparting technical education. If we look at the definition of technical institution under section 2H of the Act, it is clear that a technical institution cannot include a university. The clear intention of legislature is not that all institutions, whether university or otherwise, ought to be treated as technical institutions covered by the Act. If that was the intention, there was no difficulty for legislature to have merely provided definition of technical institution by not excluding university from definition thereof, and thereby avoided the necessity to use alongside both the words technical institutions and university in several provisions in the Act. Definition of technical institution excludes from its purview a university. When by definition a university is excluded from a technical institution, to interpret that such a clause or such an expression wherever the expression technical institution occurs will include a university will be reading into Act what is not provided therein. The power of grant approval for starting new technical institutions and for introduction of new course or program in consultation with agencies is covered by 10K, which should not cover a university but only a technical institution. If section 10K does not cover a university but only a technical institution, a regulation cannot be framed in such a manner so as to apply regulation framed in respect of technical institution to apply to university, when the Act maintains a complete dichotomy between university and technical institution. Thus, we have focused our attention mainly to the Act in question on language adopted in the enactment. In that view of the matter, it is therefore not even necessary to examine the scope of other enactments or whether Act prevails over University Act or effect of competing entries falling under entries 63 to 65 of list 1 vis-a-vis entry 25 of list 3 of 7 schedule. The fact that initially syndicate...
No, straight away, why don't you take us to straight away to the point that AICT approval is not mandatory?
That is what has been decided.
No, honestly, this is not relevant.
This is relevant, my lord.
How is it relevant?
Yes, this has held that AICT approval is not required.
Because the words that AICT approval is not mandatory.
Kindly come to last 16 paragraph. We also place on record a statement of the Council for Appellant, which our view, even otherwise, is correct position of law that the challenge of appellant with reference to regulation in a question and claim of AICT that appellant university should obtain prior approval of AICT to start a department or commence a new course or program in technical education does not mean that they have no obligation or duty to conform to standards and norms laid down by AICT. So only, my lord, the standards have to be adhered to, but no prior approval is required.
Yes, sir.
This has been followed, my lord, subsequently in subsequent judgments of Apex Court.
But there is no specific finding of the Supreme Court that it is a mandatory or not mandatory.
My lord, pursuant to this judgment, AICT itself has come out with, my lord, an communique that universities are not required to have prior approval.
Where is that?
That is in their counter affidavit.
Statement is not sufficient.
No, they have referred to this judgment.
Document.
Yes. Here, this is not AICT counter.
Annexure 4, sir, Annexure 4. It is not mandatory. Page 38.
Artist nahi, artist nahi.
It is not mandatory. Seek approval. Verify the
Kindly come to my lord, page 39. It is intimated that Honorable Supreme Court of India, in case of Bharati Darshan University and others, has interpreted provisions of AICT Act and has held that universities do not require prior approval of AICT to commence a new department of course and program in technical education. Universities have obligations or duty to conform to standards and norms laid down by AICT for the purpose of ensuring coordinated and integrated development of technical education and maintenance standards. AICT may cause an inspection of the university, which has to be as per provision and relevant rule regulation of AICT. Further, all affiliated institutions running technical education program requires prior approval of AICT. However, it has been observed that central state private universities are taking partial approval of AICT for some selected technical program, which is getting confusion. Therefore, AICT decided that no partial approval of technical courses will be given to universities. Accordingly, all universities are hereby informed that either they take full approval of all technical courses and they can continue without approval.
Where is your diploma certificate?
My diploma certificate is, my lord, annexed with supplementary affidavit. And this is, my lord, supplementary affidavit filed on 16/8/22.
Page number?
Internal page 5, my lord.
This Tirthankar Mahavir University is recognized by the state of Uttar Pradesh.
Yes, my lord.
Where is that?
Established by the state Uttar
Correct. Whether state government has approved the university?
At the top itself, it is written, established by Uttar Pradesh State Legislature Act number 30 of 2008. Similar is the situation with regard to other petitioners, my lord. They have obtained their diploma from similar kind of, my lord, universities, either private university or deemed university.
उसका काउंटर निकालिए ना AICT का आप खाली करते हैं
काउंटर निकालिए उल्टा पुल्टा रखते हैं
Then?
My lords, one more document, the counter affidavit of AICT may kindly receive. Respond number 8. Para 8 of that counter affidavit, my lord. That so far a statement made in so and so, it submitted that AICT, while its public notification for approval process had categorically.
No, para 8 starts that the petitions have taken sole ground.
My lord, is it of respond number 8?
Counter affidavit on behalf of respondent number 9. Where is the 8?
8, my lord. 8 is the AICT. Para 8. So far a statement made in so and so writ petition, it is submitted that AICTE, while its public notification for approval process 21-22 had categorically verified that central, state, public, private universities are not required to take approval of AICTE or technical program except ODL and online courses. This position has been confirmed in public notice issued for approval process 2022-23. Now, my lord will kindly come to their annexure. Page 6, annexure 1 to that. New technical institution, my lord will find the heading, third one. As per order dated, itna passed in, so next, as per order number itna passed by Honorable Supreme Court in transfer petition for existing institution offering course in pharmacy program. Next, my lord, central, state, private universities are not required to take AICTE approval as per AICTE Act. However, institutions have to maintain AICTE norms in conducting technical program. As such, some of the universities are seeking approval of AICTE for availing benefit of AICTE scheme incentive as per so and so. The central, state, private universities are not required to take approval of AICTE for teaching program except ODL and online program courses so and so. So they have made it clear. So this Bharati Darshan case has been followed subsequently, my lord, in 2 more judgments. I have given, my lord, the printout of those judgments.
Okay.
Huh? Yes. What the hell? कौन सा पैराग्राफ?
क्लियर कर दिया गया था was however that linked university article 18
My lord will first see paragraph 35 at the bottom. In para 35 of this judgment. At the bottom, my lord, last 3 sentences. In this decision also, judgment of in the case of Bharati Darshan was taken. It was, however, held that deemed universities whose courses are subject of dispute in aforesaid cases were required to abide by provisions of AICTE regulation. It could not introduce courses leading to award of degrees in engineering without approval of AICTE. The interveners, my lord, most of them are from these deemed universities. Then, my lords, in this case, my lords will kindly see paragraph 46 onwards.
46.
Yes. In the case of Bharati Darshan, this court found that in 1987 Act, there is a distinction made by legislature between technical institution per se and certain other kind of institution over which some kind of monitoring or supervision is there by properly constituted university. That would be apparent from definition of so and so. Also specifically deal with technical institution. Thus, 1987 Act recognizes the distinguishing feature of a technical institution not being university. The council constituted under it has supervisory and monitoring power over technical institution not being a university, imparting courses in technical education. This was one of the main reasoning as to why it was found by this court in the case of Bharati Darshan that the said university would remain out of regulatory ambit of AICTE. Broadly, the same logic was followed by in other authority, Association of Management of Private Colleges, so and so. The case distinguished in this decision and relevant paragraph in that regard have been referred to earlier in this judgment. None of the authorities cited above on behalf of AICTE, however, deal with situation where existing central legislation dealing with overlapping power on the same subject coming within definition of educational institution. Now, my lord should kindly come to
एसोसिएशन नंबर 13 का 8 है जिसमें फर्स्ट टाइम 3 लोग को शंका जरूरत है उसको बीच में दिया गया है।
paragraph 64, my lords, is the conclusion. We accordingly hold that so far recognition of degrees and diplomas of architecture education is concerned, 1972 Act shall prevail. AICT will not be entitled to impose any regulatory measure in connection with degree and diploma in the subject of architecture, norm and regulation set by COA and other specified authorities.
This is in respect of
Architecture.
We are not concerned with this.
Nonetheless, my lord,
Not relevant.
nonetheless, my lord, Bharti Darshan case has been relied and it
Correct, but it is nothing to do with your case.
आयुष वाला
हमको पागल कर दीजिएगा।
ये 19 का है इसके कौन साहब का मामला है
आपको असिस्टेंट से
कौन सा 2005 का दे रहे हैं आप 22 का है इसके कौन का
That's all.
one more judgment I am trying to find out, that is of 22, my lord.
Have you read that judgment?
Yes.
Have you read? Then give. Because the previous judgment you are reading now. That is the reason.
I will give that one.
Yes, who is appearing for AICT?
AICT गायब है क्या?
क्या बात हम जैसे चल रहे हैं छोटा सा जजमेंट है स्मॉल जजमेंट है
Yes, what is your stand, madam? Whether your approval is mandatory or not? Not.
My lord, para 8 in my counter affidavit, my lord, that so far the statements made in paragraph number 15 of the writ petition concern, it is submitted that AICTE vide its public notification for approval process 2021 to 22 had categorically clarified that.
No, you admit that your approval is not mandatory.
Yes, my lord.
Who is for the Who is for the Public Service Commission?
This is a small one.
Who is appearing for Public Service Commission?
In this case, it will be Bihar Technical Service.
Bihar Technical. Technically, they are not present.
ये दे दीजिए। ODL or open distance
Open distance
learning.
learning.
एक हो जाता है
Who is for the state? Yes, sir. You are the main opponent because they are challenging your action, framing rules. How to defend that approval of AICT is mandatory?
My lord, we have gone through the judgment cited by London Senior Counsel, let's say. It is largely the sole ground raised by the petitioner is, let's say, that approval of AICT is not for starting technical education.
No, for sure, any document of the AICT, that approval is mandatory.
The state do not have such documents.
Then why did you prescribe?
We have prescribed for the reason, keeping in mind the aim and objective of the AICT.
Simply you are dumping
No, my lord.
without examining with the AICT. Before framing rules, you should have ascertained the position with the AICT, whether AICT is required to be prescribed in the rules or not. Before these rules were issued, whether draft rules were published?
That instruction is required, or not. That instruction is not provided.
Huh?
That instruction is not provided to me.
You are required to proceed with the draft rules,
Yes, my lord.
inviting objection and suggestions. Where is that?
That is not, right now, that is not with me.
That is not with me and means by 2:15 you get instruction.
My lord, have been framed under
309. Correct. Draft rules is required to be published.
now, although my lord, the state has been directed to seek instructions with respect to this. May I, do I have my lord's permission just to point out two things?
No, you just point out that AICT approval is mandatory.
My lord, I'll just place that.
Yes.
Now, two provisions, my lord. First is
Appearing for?
I'm appearing respondent number 10, my lord. By the last order, he has been directed to be pleaded as respondent number 10, my lord. Order dated 29/11/22, may kindly receive.
All right, we'll come back after 10 minutes.
Oblige.
With the not frame draft rules. On that ground, from that day, everything. Draft is a matter. Already taken.
Serial number 16 continue.
My lord, in this case, I am representing on behalf of respondent number 10, my lord, who is a diploma holder, my lord, from an institute which is recognized by AICT and state government. I just place, my lord, two things for my lord's kind
What
consideration.
is your certificate? Mr. Speaker Council, you can sit now.
I have made this statement, my lord. I have not brought and recorded this certificate with.
Without that, we can't consider your case.
My lord, in that event, my lord, the state, the provisions, the last order that was passed by my lord has already taken note of the fact that we are the diploma holders, my lord.
Correct, but we want to see
This-
how in one of the for certain institution AICT is giving approval.
I'll just.
Why it is not
For
giving?
that reason alone, my lord, I'll just place that, my lord. If my lord would permit me. Bharti Dasan's case itself, my lord, would clarify that entire confusion. Section 2H of the AICT Act, my lord. It defines, my lord, the institutions that are there. If I may be permitted to place that, because that has been taken note in Bharti Dasan's case. It- 2H of AICT Act, my lord. All India Council for Technical Education Act 1987, my lord. Technical institutions.
No, bare act for AICT.
It is, my lord, in that compilation alone, my lord would find that at page 337 of volume 1. 337, volume 1. It is just two provisions of this act, my lord, and one provision of this act, my lord, and UGC act. That would clarify the entire issue that is there before, my lord. 2H. Technical institution means, may I place this, my lord? Technical institution means an institution not being a university, which offers courses or programs of technical education and shall include such other institutions as the central government may, in consultation with the council by notification in the official gazette, declare as for technical institutions. Now there is an exception which is carved out here, my lord, that is of the university. University has been defined in 2I, right below that.
There is a definition of diploma. This is only a technical institution.
My lord, yes.
The question is a diploma. Whether diploma course can be run by the institution with the approval of the AICT or by university. Now in the present case, university is also there, and on behalf of AICT is also
It is not a university in terms of section.
So therefore, you please apprise this court whether diploma, insofar as diploma course is concerned, it is within the purview of AICT and it is not with the university.
My lord, the functions of the council, my lord, have been defined. No, I do not say that. The universities can do that, my lord. My lord, with just two more provisions, and after that, my lord's question will be, my lord, I'll be addressing that question. Now, 2H, my lord, has seen right below that, my lord, is 2I. University means a university defined under clause 2F of section 2 of the University Grants Commission Act 1956 and includes an institution deemed to be a university under section 3 of that act. Meaning thereby, my lord, that the courses that may be offered by a university for the purposes of upon completion of any course of prescribed duration, my lord, in that event, AICT approval is not required. Now, so far as the University Grants Commission Act, my lord, which establishes universities in terms of section 2F and section 3, that is deemed university under the UGC Act, my lord, they do not confer any qualification, my lord, which is below undergraduation. So far as diploma course, my lord, is concerned,
Sure,
that is my
diploma is exclusively in the purview of AICT.
diploma is below, my lord, graduation. That I have shown. And then, my lord, the next question that it is.
Diploma course is a technical qualification.
My lord, yes.
Now you point out the diploma course is would fall under the purview of AICT and not the university.
My lord, I'll just place by this provisions contained under section 913, my lord, section 22(3) of the University Grants Commission Act. Universities, my lord, cannot confer diploma courses. This is what I am making, my lord. This is my submission. UGC Act may kindly be seen, my lord. It begins at page 200.
But it is the certificates are issued by the university.
That is not permissible. That is why, my lord, the government has made this categorical stipulation that it has to have the approval of AICT. Because universities, my lord, do not confer diploma, and for that, my lord, I may be permitted to place this gazette notification of the University Grants Commission, my lord.
Have you gone through the decision reported in 2013-8
My lord.
Association Management versus
My lord, yes.
where the 2H has been interpreted?
2H, my lord, to mean that anything above graduation, what I am submitting here, my lord, PG diploma courses, that is postgraduate diploma.
Have you brought the judgment?
No, I have not brought, my lord.
Without judgment, you
But my lord, so far as this case is concerned, for once, if my lord may kindly be pleased to, my lord, turn to page 23. The UGC notification may kindly be seen, my lord, where it says that it does not confer, my lord, anything by the description of a diploma. I'll just place that, my lord.
in this Association of Management of Private Colleges versus AICTA,
My lord, yes.
reported in 2013-8 SCC, the following questions were framed by the Supreme Court.
My lord.
Whether the colleges affiliated to university come within the purview of exclusion of the definition of technical institution as defined under section 2H of AICTA Act, whether AICTA has got the control and supervision upon the affiliated colleges of the respective universities. Further, whether the present case is relating to MCA. Whether the MCA course be construed as a technical education or not. In this case, it is held that university is empowered. That is insofar as MCA. Now you have
It's
to.
a post-graduation course. This is what I'm submitting. So far as, my lord, courses graduation and above are concerned,
All right, now from the regulation of AICT, you point out technical diploma course has been incorporated. Because in the regulation, AICT,
My lord.
they have incorporated this engineering, what is this? Engineering and technology.
my lord, yes.
The regulation engineering and technology was incorporated. In between engineering and technology, they have incorporated MCA.
MCA also.
During pendency of the matter before the apex court. The Supreme Court has held that retrospectively you can't incorporate. Now in the regulation, you point out technical education has been included.
In the regulation of
Diploma.
diploma has been included.
Diploma.
Now, before that, what I was trying to bring to my lord's kind notice is that in terms of the provisions under
Sir, if you point out the regulation,
My lord.
that diploma course is given by reflected in the regulation,
Yeah.
you have a case
lord,
in terms of this decision.
My lord.
Otherwise, you don't have case.
my lord, so far as their claim is concerned that the university,
Forget about their claim.
My lord.
Now you have to point out only this.
my lord,
AICT regulation,
diploma has been
diploma
incorporated.
is incorporated.
It may be, my lord,
What it may be.
it may be, we may be allowed little while, my lord. We'll just go through that and we'll bring it on record. Or, if my lord,
Who is a technical? What is your stand?
We are going ahead after framing of the rules by the state government.
So you have no role. You are just abide by the state.
We are
Correct? All right. State. When are you getting instruction whether draft rules is required to be prepared or not?
Not the prevent practice of
Don't say practice and all. We are dealing with the question of law. No practice and all. Have you issued a draft rules inviting objection and suggestions?
no,
If it is not done, we will set aside, we will treat this rule 2014,
2015,
2017 rules.
amendment in 2017.
What
Amended it in 2017.
rule is
2014 rules, we will treat this as a draft rules, asking the petitioner and others who are likely to be affected to file their objection and suggestion. And you have to notify in the official gazette, inviting objection and suggestion, give 3 months, and thereafter you finalize it after due consideration of objection and suggestion, and finalize it. It will go to the root of the matter.
Yes, my lord.
When are you getting instruction?
Day after tomorrow.
Huh?
Day after tomorrow.
All right. Heard the matter at length. Land Council for the state is hereby directed to get positive instruction by means of an affidavit of the first respondent as to whether before issuing rules called Bihar Water Resources Department Subordinate Engineering within bracket Civil Cadre Recruitment within bracket Amendment Rules 2017. Draft rules is required to be notified, inviting objection / suggestion from such of those persons whose rights are likely to be affected or not. Such issuance of draft rules is mandatory or not. These rules were issued under which directly under Article 309?
my lord, yes. 2014 itself, my lord, the rules were notified laying down the eligibility criteria, educational qualifications, everything.
Whatever it may be.
And then the advertisement was issued, my lord. They participated in the process of selection. Once they were, my lord,
Stage we are already
my lord, of course.
over.
My lord.
As question.
My lord.
Affidavit shall be filed. Instead of hearing. Release this matter next week. In the meanwhile, both of you go through the 2013 8 ACC. Appellant and respondent.
I'll also,
Throw some light.
yes, I will also,
Of section 2H, GHI.
I will also bring on,
Also, they have amended the incorporating MCA as the qualification.
I'll also bring, my lord, on record UGC regulation which provides diploma in universities. I'll also bring.
My lord, this is our case that it is PG diploma. It is not anything below graduation, my lord.
All right. You have a chance of.
My lord, yes. That list we have already brought on record, my lord. I'm trying to get a copy of the regulations of AICD.
If he's accepted, no undergraduate course of university. If his argument is accepted, then no undergraduate course of university will be allowed to operate.
My lord, UGC itself says that it does not have powers to regulate the courses below graduation, my lord. That we have brought on record.
But at the same time, university is approved by whatever the action taken by the UGC.
My lord.
University, it is approved by UGC.
My lord.
UGC is a parallel institution to AICTE.
My lord, yes. Now, for the purposes of diploma courses, my lord, the universities can confer degrees only if UGC has approved it by way of its notification. That we have brought on record. It is an official gazette. 23(5), my lord.
But when AICTE is, they are agreeing.
My lord is taking a.
They are agreeing.
They are only to the point, my lord, that where university recognizes they don't have a role to play in case of Bharti Dasan's case. In my lord, in light of the judgment of Bharti Dasan's case, they are not examining that aspect of the matter, my lord, that so far as diploma courses are concerned, they are conferred upon completion of matric, that is 10th. It is only in respect of diploma or any degree or qualification which is conferred by universities post-graduation, my lord, or
He
graduation.
himself is a diploma holder.
I am opposing because I am approved by AICTE, not by a university.
No, that is the reason. Pick and choose the method is adopted by AICTE. For some institution, we are giving approval. For some institution, we are not giving.
My lord, it is, my lord, uniform for one and all. If it is approved by AICTE, we are government polytechnics, my lord. We have due approval of AICTE, my lord, and then we have completed these courses.
So all these diploma, this diploma
valid
is to be thrown.
These are not valid for the reason, my lord, that these universities, in terms of the UGC Act and the regulations of University Grants Commission, my lord, such qualifications could not be conferred by the universities.
No, if your argument is accepted,
My lord.
such of those university who have issued diploma certificate, that is thrown.
Invalid, my lord.
That is thrown to be dustbin.
It may not be thrown, my lord. It may
Then
be, but it is not valid. It need not be thrown, my lord, but it is not valid for the purpose of these appointments.
Sorry to
I'll
say-
demonstrate that, my lord.
Very specious argument.
It is, my lord, it is strictly in accordance with section 23(5) of the UGC Act, which confers upon the commission, my lord, the powers to frame.
Article 254 has been dealt with Apex Court in 2013 decision.
Yes.
Just go through that decision also.
We will.
Article 254 is not applicable in the present case. That is what they have rendered.
Of like
10 minutes. And it is latest.
ज़्यादा दे देंगे ठीक है चलो
You are generous just to publication and